Welcome to the first Nex Gen podcast series produced by the LIDC, Ligue internationale du droit de la concurrence, International League of Competition Law. Throughout a series of 7 episodes, our expert guests will explore the intersection of competition law with emerging technologies like cloud computing and artificial intelligence, and will delve into the legal, economic, and policy challenges these innovations pose to competition regulation worldwide. All the views expressed throughout this podcast are the speaker's own and do not represent the views of the LIDC nor any of the companies and organizations with whom the speakers may be affiliated or the clients they represent.
So it's a pleasure to welcome you to this further episode of our series, which is discussing competition issues in cloud and AI. This time we're going to focus on a really quite a thorny topic, I think, and a really current topic within competition law circles, certainly, and that is the issue of mergers and acquisitions. So we're going to discuss some of the recent developments, particularly in the EU and in the UK, and we're going to focus on principally those jurisdictions and whether or not certain types of transactions can or can't be captured both by merger control and also sui generis regulation in the form of the EU Digital Markets Act. So perhaps to start us off, Shruti can take us through some of the UK side of things with this.
Happy to. Thank you, Ben. So I think what we're seeing in the UK is that the CMA is very actively monitoring strategic partnerships between major tech companies and AI startups on the basis that these sort of arrangements could potentially consolidate market power in relation to the AI and cloud sectors. So I think one of the key examples of that is the CMA's investigation into Microsoft's partnership with Inflection AI, not partnership, but rather what happened there was that Microsoft, and you're seeing more and more of this in the AI space, the so-called acqui-hires, where a company does not fully acquire another company, but it acquires certain key employees of that company. And what happened in Microsoft Inflection was that Microsoft acquired certain key employees, including the founders of Inflection AI, and also entered into a non-exclusive licensing relationship with Inflection AI. And while you would have not thought that this would qualify as a merger, that would merit a merger control proceeding, the CMA in that situation said that actually the fact that Microsoft hired certain key employees and also entered into a non-exclusive licensing arrangement with Inflection AI effectively meant that the two entities were no longer distinct, and therefore that this was a relevant merger situation that they could investigate. Now, they ultimately decided that there wasn't a substantial lessening of competition as a result of this acqui-hire, and so they cleared the transaction. But it is, I think, very interesting to keep in mind because this was a new sort of situation that was considered to be a relevant merger situation from the CMA's perspective. The other sort of type of transaction the CMA is increasingly scrutinizing are minority stakes in the AI and cloud computing sector. So examples here are Google and Amazon's minority investments into Anthropic. So I think, again, here the Google investment is the investigation into the Google investment is still ongoing, so we'll have to see what the outcome is. But CMA has cleared Amazon's investment into Anthropic on the basis that the minority investment does not amount to a merger. So they've accepted that this is not something that is within their jurisdiction to scrutinize. But I think it's still interesting and noteworthy because that means that the CMA is keeping a very close eye on what is happening in this space, and it's actually gone out of its way to call these in to look into them. And so that means they're taking a very proactive approach to these sorts of strategic partnerships. So I think in terms of what implication this has for future transactions, I think there are two. One is that more and more strategic partnerships and even minority investments are going to be subject to scrutiny. And the second is be prepared for a potentially lengthy CMA review process, depending on the issues involved in that particular sort of transaction or partnership.
Fascinating. It's kind of uncharted waters, really. I think in merger control. The situation, if I can reflect on the EU situation, it's also interesting and complex, particularly after the recent CJEU ruling in Illumina. I won't go into great depth on that one, but just simply on its implications. So, one thing that's very interesting before I get to that is just echoing, I suppose, some of what Shruti said in the UK, that where, for example, the EU in Microsoft OpenAI, were considering whether or not there was indeed sufficient, to merit a full merger inquiry. Where they found that, in fact, no, they couldn't investigate this under merger rules. They've, in fact, then diverted attention to just one aspect of this, which is the exclusivity clause. And it touches on what we were talking about with the stack in previous podcast sessions, because in this deal there is an exclusivity clause which basically ties Microsoft's formidable cloud infrastructure to OpenAI, or rather the other way around. And so, that's under investigation. We'll see what comes of that, whether or not it yields something. But I guess that, from both sides of the channel, authorities are encountering, obviously, difficulties in putting a number of these novel, let's call them transactions, into old merger control boxes. And if we think about, so I'll think about now Article 22 and Illumina, because, it was interesting that in Microsoft Inflection, on the EU side of things, pre-Illumina, so Illumina basically, in a nutshell, is the CJEU closing down a door which the Commission had potentially creatively, if I can be kind, opened up, whereby it saw an opportunity to review so-called killer acquisitions. The empirical evidence on that to be discussed hugely, but so that they could review, these acquisitions that would fall not only under the EU's merger control thresholds, but also under member state thresholds, and yet still review with a recommendation, a referral from a member state. So that's been closed down. And what happened with Microsoft Inflection is that after Illumina closed that avenue down, we saw that a number, indeed all of the member states that had made a referral to the Commission then withdrew that. And so in September 2024, I believe, so just a couple of months ago, that really sort of put that to bed. Very interestingly, though, Article 22 is not dead and buried, because, of course, if genuinely the national member state merger thresholds are met, then we can obviously continue to have a referral. And so NVIDIA and Run AI is a transaction that just a week ago has been notified by the Italian authority. And so the Commission will pick up on that and review that as a potentially problematic merger under its regular merger control regime. But I think that one of the most significant implications of Illumina is actually for the Digital Markets Act, and so moving away from traditional merger control and thinking about how we can, if we put the Commission's hat on here, start to address those same killer acquisitions by large incumbents. How can we address those? The DMA in Article 14 kind of paved what some hope would be a way for this to happen, a second way for this to happen. Illumina, of course, by closing down that below threshold, below both EU and member state threshold, carve out that the Commission had envisaged, has potentially also put the brakes on Article 14, although only temporarily, I would say. And so we can already see, I think France is an example of this, a real energy around tweaking national member state thresholds so that Article 22 can indeed be used so that the Article 14 of the DMA can have fresh life, so to speak, and that acquisitions that the Autorité de la Concurrence, I think, have referred to as acquisitions by AI gatekeepers can potentially be addressed. So I think that in Europe, maybe for the time being, we're going to potentially see a little less activity. But if member states do indeed follow through and change thresholds, and indeed if the Commission, we have a new Commission, so Vestager was, I think, quite pragmatic in wanting to maintain continuity, legal certainty, didn't want to tweak thresholds. We can't speak for what will happen in the new Commission. Will there be a review of EU merger regulation? I don't know what that would look like. But I think that in the longer run, we can potentially envisage a Europe in which, some of these transactions are, by one means or another, put in front of the spotlight and unpicked. And I guess that to touch on one other area that I think is interesting is the development of theories of harm in merger control. And, we have this new, it's been in the academic literature for quite some time, but it's made it to the real world, so to speak. And it's ecosystem theories of harm. So we don't necessarily have a particularly clear articulation from the Commission side of things as to really what an ecosystem theory of harm is, what it looks like. We have Booking e Travelli, which it's a conversation for a whole other podcast, but it opens up a potential can of worms. It basically, does it put a blockade on any acquisition of a complementer by a firm with a certain market power potentially? Is that pro-competitive? Is that anti-competitive? Question to be raised. But the reason I think ecosystem theories of harm are interesting for AI is that it relates back to our earlier podcast discussions. When we step back and we think about some of the concerns that have been raised around companies that control many aspects or all aspects of the stack, does an acquisition or does an interest in or an acqui-hire or any of these kinds of activities, these kinds of transactions, does this raise concerns around firms building out their ecosystems in a way that could harm competition and ultimately harm innovation? So I think that from the European perspective, it's very much all to play for, and I guess that being to some extent a fan of, if I can use that word, of the Illumina judgment, I would just kind of underscore the importance of legal certainty. I would also underscore, my deep concern with this kind of movement that is very keen to unpick mergers. Again, I think, that once a merger is cleared, parties get on with their lives, they make long-run investments, so the work has to happen at the beginning. And so I think that, for me, the kind of cautionary word would be, take this one very, very methodically, slowly, carefully, and don't potentially risk blocking transactions that, as Shruti has rightly outlined, are often, and in previous podcast episodes, it's really pro-competitive, allowing talent to thrive, allowing small startups to grow. So that would be my thought on the EU.
I just had a couple of quick examples to add to the point you mentioned about the tweaking of the threshold that just popped to my mind. I mean, you are seeing the tweaking of thresholds. I mean, you mentioned France, but we already have deal value thresholds in Austria and Germany, for example. India has recently introduced deal value thresholds. So, who knows? There could be more countries introducing those sorts of thresholds. And the other interesting example of tweaking of thresholds is actually the UK, because we're going to have a new sort of test for merger control transactions that qualify for merger control in the UK, and that'll sort of capture any transactions where one party has anything more than 350 million in revenue and more than 33% of the share of supply of a market, and the other party has a link to the UK.
Absolutely.
So, the other party, so it's not a deal value threshold, but it's kind of trying to capture the same type of transactions in a way that deal value thresholds are trying to capture, which is the ones where the target is a startup with no revenue, which is not yet revenue generating, or generates revenue but is well below the thresholds. So it's trying to do that through another means without the complications of getting into deal value.
Absolutely.
So I think these are some interesting examples that we're seeing in different jurisdictions already, and we may see more of that as time passes.
Thank you for listening to this episode of the Nex Gen podcast by LIDC. To stay up to date with future episodes, we invite you to visit the LIDC website and subscribe to this channel. We look forward to having you with us again soon.